crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of Xrp, over 75,000 Xrp investors are represented by John Deaton in the continuing legal dispute between Ripple and the United States Securities and Exchange Commission, CEEELFUCE. Deaton recently spoke at the first OnxTC Live Blockchain Industry Conference in Texas, where he offered some noteworthy observations. Deaton's speech elucidated the idea of qualified immunity, an important legal component that might call the SEC's actions into question. When performing their official responsibilities, government employees like those at the SEC are protected from personal culpability by qualified immunity. Deaton stressed that this protection is a major roadblock to holding regulators accountable for their actions. Deaton brought up the Bernard Madoff case, in which investors sued the SEC for inaction in the face of numerous warnings about Madoff's infamous Ponzi scheme. The judge's decision to throw out the lawsuit shows how difficult it is to hold the SEC responsible. Deaton explained where things are with the Ripple case's appeals process. A full appeal may not be filed until after the trial has concluded if an interlocutory appeal is already being considered. Deaton considered the possibility of SEC witnesses or mediators, among other options. The SEC's position on the security status of other cryptocurrencies may influence the settlement, making the latter alternative more or less likely depending on the outcome of the Coinbase case. The SEC may have to wait until late 2020 for the Second Circuit to hear its complete appeal after Deaton's prediction that Judge Annalisa Torres would refuse the interlocutory appeal. The legal intricacies of Ripple's fight against the SEC were revealed by John Deaton's remarks at the OnxTC Live conference. An important barrier to holding the SEC and its personnel responsible is the concept of qualified immunity. The Coinbase case is now in the appeals process, and its conclusion will have a significant impact on the future course of any possible settlement. In spite of the current legal processes, the Ripple community, led by John Deaton, has maintained its unwavering support for the firm. Partnerships, technical innovations, and collaborations within the digital asset ecosystem continue to evolve, fueled by the need for clarity and regulatory stability. Ripple's dedication to changing the way money is transferred internationally and domestically is shown by these endeavors. Surprisingly, the U.S. Securities and Exchange Commission, SEC, has asked a federal court to let top SEC attorney Pascal Guerrier to withdraw from the litigation against Ripple and Xrp. Since then, the senior lawyer has formally withdrew from the case, throwing the legal processes into more doubt. The SEC's legal campaign against Ripple included important contributions from notable figure Pascal Guerrier, who is well known for her expertise in securities law. There has been much conjecture as to the cause of her abrupt departure since no explanation has been given. First, Guerrier's departure may indicate that the SEC is split on how to go forward with its investigation into Ripple and Xrp. Given her high rank at the agency, her resignation may indicate underlying problems with the SEC's approach to the case. Second, the judicial system may experience delays as a result of this new information. When changing lawyers, there's often a period of time spent as the new group learns the ropes of the case, which might slow things down. Finally, some in the cryptocurrency industry see this as good news for Ripple and Xrp. There's been conjecture that the SEC is having trouble proving its case against the digital asset, despite the fact that it is impossible to forecast legal results based only on changes in legal teams. Finally, the SEC's decision to dismiss Pascal Guerrier from the Ripple complaint introduces a new and intriguing dynamic into an already contentious and highly followed judicial struggle. As the case progresses, everyone will be watching to see how this change affects Ripple and the future of Xrp. And SEC disclosure was made public thanks to the tweeting of Fox Business reporter Eleanor Terrett. The Commission has notified the judges of the acceptable and unacceptable court appearance dates for the second quarter of 2024. Ripple's CEO Brad Garlinghouse and co-founder Chris Larson's legal representation have notified the presiding judge that their clients would be unavailable from April 1 to April 14, 2024. Since that time, the trial for the legal issue has been pushed out until April 20, 2024. The SEC and Ripple Labs have agreed to begin formal litigation in the second quarter of 2024. The SEC has detailed particular conditions for participation, despite the fact that the corporation is given a flexible schedule and offered to engage in proceedings at any moment during the term. Both Ripple and the SEC have confirmed in formal letters to U.S. District Court for the Southern District of New York Judge Annalisa Torres that they expect to go through with the appeals in the second quarter of 2024. This latest correspondence was prompted by a court order granting an interlocutory appeal to the SEC in the continuing lawsuit against Ripple on August 17. This followed the verdict from July 13 that gave each side some success in the case. It has been claimed that the absence of Ripple's top executives coincides with the expected Bitcoin halving, a major event in the cryptocurrency market. On or around these dates, the Bitcoin network's mining incentives will decrease. Challenges with regulators have been a major stumbling point for Ripple and its digital currency Xrp. John Deaton, an authority in cryptocurrency litigation, explains how the U.S. Securities and Exchange Commission (SEC) has stymied Xrp's development. An advocate for Xrp, attorney John Deaton, recently turned to Twitter to voice his displeasure with the cryptocurrency's performance after the implementation of the Ripple V's Securities and Exchange Commission secured litigation. Following its recent investment in Circle, a significant USDC stablecoin on its platform, Coinbase has released a statement explaining that it spoke with SEC lawyers before deciding to list Xrp. Without the SEC case, Deaton says Coinbase could have gone with Ripple instead of Circle. It's interesting to compare the transaction times of Coinbase's Xrp and Circle's USDC, which were both published around the same time. The process of getting Xrp back on Coinbase was more involved than just another purchase. Due diligence was required, and it was carried out with great care to guarantee that all rules and regulations were followed to the letter. To successfully traverse the regulatory environment, Coinbase took preventative precautions by communicating with the U.S. Securities and Exchange Commission (SEC). This interaction was essential in establishing the legitimacy of Xrp as a digital asset rather than a security. There was a meeting between the SEC and Coinbase to talk about how to categorize Xrp. Coinbase and the SEC had a conversation on Xrp, and interestingly, the SEC did not raise any objections. John Deaton, the CEO of Coinbase, released a statement in which he expressed optimism about the company's regulatory harmony in light of its plans for an initial public offering. Deaton has seen that Coinbase has been actively promoting Xrp and another stablecoin, USDC, during the last several months. When compared to the time and effort required for conventional bank wire transfers, digital assets were seen as revolutionary by the exchange. An unexpected turn of events occurred during the intensive advertising campaign. Former SEC Chairman Jay Clayton's lawsuit against Ripple, which alleged that Xrp was being traded illegally as a security, sent shockwaves across the cryptocurrency market. Despite the SEC's prior statements to the contrary, a complaint was filed challenging whether or not Xrp should be considered a security. The SEC allowed MoneyGram International Inc.'s use of Xrp in its international payment system 18 months ago, but that didn't stop the new legal action. The SEC allowed MoneyGram International Inc.'s use of Xrp in its international payment system 18 months ago, but that didn't stop the new legal action. Deaton stresses the negative effect of legal disputes on Xrp's future development. These obstacles have stopped us from taking full advantage of our situation and have cost us valuable time and resources.